Good afternoon, everyone. If you're joining us on the East Coast, my name is Whitney Stoll. I am your DC Post First Vice President. Joining me is Bree Beal, who is our Programs Director, who is hosting our webinar today and will be monitoring our chat. So thank you all for joining us on our new platform. We have nearly 100 registered participants from all over the country. So I know you're excited to be here with this program as we are. So it is my pleasure for welcoming you all to our October First Friday luncheon session. So please join me in welcoming Maria Panichelli from McCarter & English, who will be presenting the common contractor mistakes in asserting and defending bid protests. We're going to be diving into understanding the who, what, and when, where, and why in bid protests, so you can make the right decision for your business and understanding the rules of engagement in federal contracting. But first, I'd like to start by welcoming you all to our First Friday series, which is provided to you through SAME's commitment to offering the AEC community effective training, development, and networking programs. The DC Post is helping to sustain the future of the profession with these monthly education-focused sessions, but to deliver topical and relevant content to our industry. So thank you all for joining us here today and as we start our program. So please feel free to use the chat to introduce yourself to everyone throughout the presentation, ask questions so we can address them during the Q&A portion of the event. Also, this is a lunchtime session for those joining us on the East Coast, so please feel free to eat your lunch during this the program. So we are glad you can join us here today and offer this virtual program to our community, regardless of where you're calling in from. So let's start with a moment of silence to remember our active duty military, first responders, and all who need our care and thoughts throughout the world right now. Thank you. And now if you please join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We'd like to take a moment to thank all of our DC Post sponsors for your support. We have AMT, Black & Beach, Christopher Consultants, Consigli, Fox Rothschild, Gannett Fleming, Spiniello, Stantec, WSP, Jacobs with Peacock, AB Facility Service Solutions, Arche Consulting, Prime AE, and Stanley Consultants. So we truly do appreciate your support. We could not have pulled these events off without you, and we are grateful for your outstanding sponsorship. Your support helps us meet our society's strategic goals, including providing excellent content for our members, industry and government engagement, building resilient communities, connecting with our future leaders through our student and young member groups, enriching the STEM pipeline, and preparing our military and veterans for life after the service. If you're not already a DC Post sponsor and like to support our post with annual sponsorship, we'd love to add your name to the list for future programs and events this year. So please visit our website for more information about sponsorship levels and how you can give back to the community through the sponsorship. And now onto our main program. And please note that this program will provide one professional development hour from the DC Post, and look for an email with the subject line document delivery from SAME DC and Eventbrite with a copy of the program slides, your PDH certificate, and a list of opt-in attendees who pre-registered for the session. So we are recording this webinar and we'll post it on the video on our website later on. So I'm not going to read to you all the learning objectives for the slides, since most of you already saw the objectives when you registered. Instead, I'm going to introduce to you Maria. So while I do the introduction, if you haven't done so already, please use the chat, introduce yourself, share contact information, where you're calling in from, your LinkedIn contact information, and please feel free to use the chat throughout the presentation to share comments and ask questions to the presenters. And also, if you'd like to save the chat with all the contact information, feel free to go to File, go to Save, and click on Chat so you can save all the contact information as well. If there's a particular slide you'd like to talk about, please share that in detail for your chat question, and we will answer the questions at the end of the program. So Maria Panichelli is a partner with McCarter & English's government contracts group and represents clients with a wide range of industries nationally and internationally. Maria specializes in procurement processes, protests, contract interpretation, and compliance counseling, and is experienced in federal subcontracting, contract terminations, and small business programs. Maria is an active industry member, lecturer, and author of government contracting and small business procurement topics. So, Maria, thank you for joining us again, and I'm going to turn the program over to you.
Well, thank you so much for that lovely introduction, and thanks to everyone out there joining us today. Excited to be here to talk to you about protests in this lovely protest season. Hopefully you can see my slides. I guess Whitney, Bree, let me know if you can't. But we're going to be talking today. I'm going to try to walk you through this content in a way that's a little bit more, I guess, interactive, but also, looking at it with a specific framework in mind. Instead of just kind of walking through the steps, attacking the things that you need to know in the framework of the most common mistakes I see. As you heard, my name is Maria Panichelli. I am a partner and a member of the government contracts practice group at the law firm of McCarter and English. We are a full service law firm. We have over 400 attorneys, but my group focuses exclusively on federal government contracting. All we do all day, every day is procurement. And then we've got folks in, kind of complementary areas like white collar crime and general litigation and labor and employment and things like that, that kind of, help us out on certain cases. But my practice runs the gamut, everything and anything that comes up by virtue of doing business with the federal government. We help clients navigate every stage of the procurement process. So that includes, general performance and compliance counseling, REAs, claims litigation, subcontracting issues, and, the myriads of things that kind of go into that, including the documents themselves, disputes arising out of them, Miller Act claims, liquidating agreements, pass-through claims, etc. I do a lot with small business procurement, so teaming, mentor, protege, joint venture, eligibility analyses, working on a couple size and status protests right now. And of course, my practice also includes what we're going to be talking about today, which is bid protests. I represent clients on both sides, people who are protesting and people who have been protested. So I have seen many of these cases and know a lot about the ins and outs and kind of what you need to do. So we're going to start today by talking about the fundamentals, and then we're going to move on to kind of 9 specific major mistakes that I see contractors make. The most common things I see contractors do wrong. We only have an hour, and I want to leave some time for questions at the end. But as what you said, you can throw your questions in the chat box as we go. But we're going to leave some time at the end as well. But this is a very complicated area, and we have a short amount of time today. So don't think that the goal is to leave this having memorized all of this. Your head would pop off. The goal today is to leave kind of understanding the framework and understanding enough to know when you're in kind of a hot button area, knowing when you've hit a trigger point or a catalyst or a jumping off point, or you've stumbled into an area where there's going to be a clock that starts ticking, or where you've got to do something to keep your foot in the door, or where you need to make sure to ask a certain question. I want you to walk away today with an understanding of the broad brushstroke framework and the critical moments where you need to act. And, hopefully if you also walk away with what you need to do in those moments, great. But if you don't, you'll at least know that that's the time when you need to call someone who can tell you what to do. So we're going to talk about the fundamentals. We're going to talk about size and status protests versus bid protests. We're going to talk about where you can file protests. We're going to talk about a couple of the mistakes relating to deadline calculation. We're going to talk about debriefings, and then we're going to talk about how to spot a winning protest as opposed to a losing protest, so that you guys can make the go, no-go decision with your teams. And then finally, we're going to talk about, what to do on the other side if you are the protested concern and not the protester. I like to start with the fundamentals, the mistake one that people forget the fundamentals, because this is one of those areas where there is a ton of misinformation out there and a ton of misconception. A large reason for that is that, as you're going to see, there's no kind of one size fits all, this is how a protest always works. There are rules, but kind of where you are in those rules depends on a lot of different things. So even if you are a very sophisticated contractor and you've gone through 4 bid protests before, it's very possible, probably likely that the next bid protest you're involved in might go a different way. And I don't just mean in terms of results, I mean in terms of how you calculate the deadline, whether or not you get to ask additional questions after your debrief, whether or not you've got to file within 10 days or 5 days. So there are a lot of different things that are very fact specific. And even the most sophisticated contractors can kind of make mistakes because they think that everything works the same every time. And it doesn't. It's very, very individualized based on the particular procurement at issue. So for that reason, I like to start with the fundamentals and build upon it from there so that everyone can kind of understand, oh, okay, that's not a one size fits all process. There are different ways that this goes. The biggest thing to understand is that the law governing protests, much like most things in government contracting, starts with the FAR, starts with the Federal Acquisition Regulation. That's going to govern substance and procedure. So when you are talking about a bid protest and you're challenging kind of, what went wrong in the process, and we're going to talk more about that as we move forward. Those arguments are often going to be tied back to the FAR, but the procedure for protests is also outlined in the FAR. You might also have applicable supplemental agency acquisition regulations, other government contracting related statutes. Small business regulations are most definitely important for small business size and status protests, but they can also become, depending on the arguments, important for bid protests as well. As we're going to see as we move forward, there's different places you can file bid protests. So the other important or applicable law is going to be the forum rules, the rules of those places in terms of when you need to file and what you need to file. And although this is not the law, obviously, protests are all about, saying that there's something wrong with the resulting award decision that was made. And the thing that you're going to do as a protester is say, well, here's what should have happened under the law, and here's what did happen. And you're going to be comparing those two things. Well, here's what did happen. One of the things you're going to be comparing it to is what should have happened and, what the law said. But when you're comparing it to what the law said, you also should be comparing what really happened to what the solicitation said was going to happen. So on one side, you've got, what did the law say should have happened? What did the solicitation say was going to happen? And then on the other hand, what did happen? So I put the solicitation on this slide just because it, like the law, is a comparison point that you're going to compare to what actually happened. In terms of, the protest timeline, obviously those of you who've gone through many procurements have, are well aware of this. And this is obviously a simplified timeline somewhat, but we're trying to keep things as easy as possible for today's presentation. So you've got a solicitation that drops, whether it's an RFP, an IFB, RFQ is going to depend on the nature of the procurement. Most likely you've got some sort of Q&A period with the government. You're then going to respond to the solicitation, get your proposal in, get your bid in, get your quotation in, whatever the case may be. If it's a FAR Part 15 procurement, contracting by negotiation, competitive procurement, you may have competitive range discussions, and we're going to talk about what that is a little bit later. If there is a competitive range selected, you're going to get notices sent out at that point. Then there's going to be an evaluation process of the vendors, the offerers, the bidders, whatever the case may be, and an award decision. Then there's going to be some pre-award notices. Then there's going to be an award. Then there's going to be post-award notices. We're going to talk about, remember I said that the goal here when you leave today is understanding the different jumping off points, understanding the different catalysts, the different triggers. We're going to be coming back to this timeline today as we move forward. For now, just keep in mind this is the timeline. The critical questions and considerations is something that I want you to keep in mind as we go forward as well. Remember that I said protests are not a one size fits all type of deal. What happens and how things unfold and what your deadlines are and how you calculate them and if you get enhanced debriefing and if there's a threshold dollar wise and what that threshold is, all of these things are going to depend on the answers to these questions. It's kind of a choose your own adventure or a very confusing flowchart, if you will, where, depending on what agency you're dealing with, what type of contract is at issue. And by that, I mean, is it an IDIQ? Is it a GWAC? Is it a task order? Is it a BPA under a GSA schedule contract? Is it some other sort of multiple award schedule or multiple award vehicle? These are the types of things, and also what method of procurement. And by that, I mean, is it sealed bidding under FAR Part 14, where as long as you're the lowest price, as long as you're responsible and responsive, the lowest price is going to win? Is it simplified acquisition? Is it commercial items contracting? Is it contracting by negotiation, where there are price and non-price factors and the government has to do a trade-off evaluation and select best value? The answers to those questions are going to put you in kind of different places in the flow chart, different places in the choose your own adventure, and you're then going to follow a different path through the maze. Mixing a lot of metaphors there, but through the maze of government contracting. And of course, again, going back to that forum rules issue that I raised before, where the protest is being filed is also very important. And again, obviously, those are the fundamentals. We will be expanding on all of them as we move forward. One of the most kind of threshold before we get into the meat of bid protests themselves, one of the biggest and most unfortunate mistakes I see contractors make at a very threshold level is that they confuse bid protests with size and status protests. The reason that that is a problem is that there are different rules, even within we've been talking about within the confines of bid protests, there are different ways things can go. But there's a completely different process, completely different set of rules, completely different places that you bring the protests when you're dealing with size and status protests. So it's very important as a protester to understand what type of challenge or challenges. It's possible that you can have all of these on the page, that you have to kind of challenge or object to an award that's been made to a competitor, and that you're kind of proceeding on the right track to exercise your rights with regard to one or all of these things. So the difference is a bid protest is a challenge that's raised by a contractor, usually a disgruntled competitor if there has been an award, or a prospective bidder or offerer if you're at the pre-award stage. And there's an issue in terms of alleged improprieties in the source selection process. So whether it's that there's something wrong with the solicitation itself, or there was something wrong with the discussions that were conducted, or there's something wrong with how the offerers were evaluated and who got the award, the idea is the agency did something incorrect. They made a mistake, or at least that's the allegation. Somewhere in the process, the agency did something wrong that resulted in the wrong contractor or contractors getting the award. Compare that to size and status protests, where it has nothing to do with what the agency did or didn't do. The idea is the awardee should not have gotten the award because they're not eligible. This comes up in in set aside contracts. Contracts where it's not everyone and anyone can bid. The government has said, only 8A contractors, or only small contractors, or only hub zone or women owned or service disabled veteran contractors can bid. It might be that the allegation is that they're not actually a small business, and therefore, because they're not a small business, they can't be a service disabled veteran owned small business. That's a size protest. Or it could be that regardless of size, they don't meet the other criteria. So it might be that you are challenging the fact that a woman actually, majority owns a company, or that a service disabled vet actually unconditionally controls a company. Those would be status protests. We're focused today on bid protests. I will try to kind of just loop you in and kind of make tangential comments of places you need to be aware of key differences with size and status protests. But again, the idea here is, know which one of these or ones of these you have. We're going to be talking about the processes and mistakes relating to bid protests. There are also size and status protests. It is entirely possible. I've had many clients come to me where they say, well, the agency did something wrong. These guys shouldn't have gotten the award. But even if the agency, even if we lose on that, these guys shouldn't have gotten the award because they're also not a real STVOSB, or they're also not a real woman-owned company. So you might have multiple types of protests you can file. Now, in terms of where you file, you don't want to file in the wrong place. And this kind of dovetails into what I was just talking about with size and status protests. Bid protests, you've got three options. You can file with the contracting officer, that's an agency level protest. You can go to the GAO, or you can go to the Court of Federal Claims, or COFC. Generally speaking, for reasons we're going to discuss as we move forward, the default is the Government Accountability Office. Usually that's where contractors want to go. Usually that's kind of considered the default unless there's a reason to go to the agency or the Court of Federal Claims. Reasons to go to the agency can include, especially if it's like an administrative or clerical or really simple, kind of not subjective judgment based protest, it can be cheap and quick and easy. So that's a good idea. Court of Federal Claims, you might want to go if there's a lot of protesters, and you have to go if one of the protesters in a consolidated protest already went to the Court of Federal Claims. But generally, and some deadline reasons, if you've already kind of blown the deadlines at the other places, you might want to go to the Court of Federal Claims. But it can be more expensive, and for other reasons we're going to see, it's a little bit more onerous to go there. This is something you should discuss with your attorney, though. You should talk about the relative benefits and drawbacks of each of these venues. There are reasons to pick different venues at different times, and you're going to want to make sure you kind of walk through those with someone who understands. Do you want more bites at the apple? Do you want to keep costs down? Do you want an automatic stay? These are the things you need to work through. Compare this to bid, these are bid protests. Compare this to where you file size and status protests. You file them, and again, we're not going to focus on these today, but just so you know, you file them with the agency, with the contracting officer, but then they get forwarded to different groups within SBA. So we're not talking about the GAO, we're not talking about COFC, we're not talking about the agency making a decision when you're talking about size and status protests. The agency is the gatekeeper, but it's the SBA. And especially now that they've consolidated the veteran-owned programs, it used to be the SBA and sometimes the VA. Now it's just the SBA, but different groups within the SBA, different offices that are going to be making the decisions on size and status protests. So again, it's important to understand, you don't want to try to file your size and status protest with the GAO. You don't want to try to file your size and status protest with COFC. You don't want to take your bid protest to the SBA. It's important to keep these things separate. Now, here's one of the places where I'd like, if you guys could, to be a little bit interactive. How many of you out there have been or have been involved, or whether on the protester side or in the intervenor context, which we're going to talk about a little bit later, involved in a protest? Just say yes in the comments in the chat. Any of you? Yeah, okay. See, the answers are pulling in. Many of you have been involved. Now, if I were to ask you, what's the deadline to file a protest? What would you guys say? Feel free to type it in if you think you know the answer. All right, so I'm getting a lot of people saying 10 days. 10 days, whatever the lawyer says. Very funny, yes. And the person who said there is none. True in that there is no one answer. So I've got people who are saying 10 days. That is true sometimes. And even when it is true, 10 days from what? So that is probably one of those things where I said, even the most sophisticated contractors, they've got a spot answer, right? 10 days, which, as we're going to see, is true in a lot of protests. But where you count that 10 days from, and it's not always a 10-day question. So it can be something that, even the most sophisticated contractors, because they've gone through it before and it's been 10 days and they know what they did, they think it's the general rule. There is a rule, and then there is an exception to the rule. And there are different rules for pre-award and post-award. So we're going to take kind of a look and walk through all of these one by one. There's no one size fits all rule for when is a protest due. It's broken down into different types of protests, different types of forums, different types of procurement, different situations. So remember I talked about those answers to critical questions. Who are you dealing with? What method of procurement? What type of contract? This is where the answers to those questions start to shoot you off into different areas on the flow chart in the choose your own adventure. Like I said on one of the earlier slides, GAO is often the default for reasons we're going to talk about later involving the automatic stay. So we're going to focus on GAO deadlines today. But again, one of the things you should be talking about with your attorney if you think you have a protest is, are we going to the GAO? Okay, I know I have some semblance of the deadlines, some idea of the deadlines there, but you want to talk about what the deadlines might be if you went other places as well. Generally, it's going to be pretty consistent if you go to the agency. You've got more time if you go to the Court of Federal Claims. So we're now going to move into the part of the presentation that's kind of, a couple different mistakes all grouped together under the headline deadline mistakes, miscalculating the deadline. And the biggest kind of conceptual idea that I want you guys to get out of your heads first is that this idea that, well, everything happens after award. I don't have to do anything until there's an award that goes out. Not true. There are at least two circumstances where you need to act before award. And the first one is when there's a protest where you're trying to challenge the terms of the solicitation. So this is one that not a lot of contractors are familiar with. Some don't even know that it's a possibility. Most contractors are most familiar with the post-award protest that we're going to talk about a little bit later. But like I said before, there are different protests for different types of, different deadlines for different types of protests. And pre-award protests based on errors in the terms of the solicitation are one of the deadlines that's different. And these protests must be brought really early in the process. In fact, they need to be brought before the deadline to respond to the solicitation. So what kind of things might be protested at this stage? Well, you look at the solicitation and stuff's inherently contradictory, or it's really ambiguous and you don't really know how you're supposed to interpret it. In the construction field, the specs are wrong. There's a defective spec. The specs can contradict the drawings. There's something in the scope of work that contradicts the specs. Contradictory stuff. A lot of times with construction, especially, you see that. Inclusion of prohibited terms, exclusion of things that are supposed to be in there. I actually had one once where the the VA contracting officer had cut and paste a bunch of GSA regs and GSA supplemental clauses in there. That's a problem. Unduly or overly restrictive terms. This is where the government has narrowed competition way more than is necessary. Whether it's, hey, we've made the requirements for the widget so narrow that like only one company can really fulfill them, or maybe it's that, we're looking for someone to build this kind of, project. So we've specified that we want them to have experience of the same scope and magnitude and nature. That's reasonable, and it has to be within the last 3 months. Why? And it has to be in this particular county, in this particular place. Why? So sometimes it's going to be, if the government can justify why they have such a narrow requirement, that's fine. But the default in the American procurement system is full and fair and open competition for all. So the government really has to have a justified reason for narrowing the competition. And if they're doing it too narrow, more than necessary, that's going to be a problem. But again, it's something that you need to, look at the evaluation factors. And if something seems way too specific, obviously, if it kicks you out of the running for being eligible, this is when you're going to want to protest. Other inconsistencies with the law. So remember I said, when you're talking about a protest, the law and the solicitation are over here, and what actually happened is over here. Oftentimes when you're talking about the pre-award stage, it's what does the law say versus what does the solicitation say? It's a little bit different, right? So inconsistencies with the law, things like, for those of you who know what LPTA is, lowest price technically acceptable, that was a kind of method of competitive procurement under FAR Part 15 that government started getting really fond of. Basically means that you have to be this high to ride the ride in terms of technical, but after that, it's just lowest price. There's not a best value trade-off. As I'm sure many of you are, either new when you had to do it or, would think that's really hard to bid and to figure out how to kind of get a technical approach that's good enough with then not, overpricing yourself on the pricing side. After a lot of pushback from contractors, the law changed. LPTA is not supposed to be used as often as it was being used, but you still will see it. So this, if you see it somewhere where it's not supposed to be and you don't want something to be LPTA, when the solicitation comes out, that's the time to protest it. Another common one that comes up is the small business regs do talk about joint ventures and teaming partners and how they're going to look at the capabilities of joint venture and teaming partners. If they're doing something, if they're saying in the solicitation that they're going to evaluate teaming partners or joint venture partners in a way that's inconsistent with those regulations and that's bad for you, this is when to speak up. Anything relating to Rule of Two or Kingdomware, if for those of you who are familiar with the SDVOSB Rule of Two, anything about whether this is set aside and shouldn't have been, or isn't set aside and isn't set aside and should have been, or is set aside and shouldn't have been, can come up at this stage. And also for small business set asides, if there's kind of pass fail requirements, you can sometimes make the argument that's a de facto responsibility determination that should be something that's referred to the SBA. But not an exclusive list. These are examples. These are the most common, but these are the types of things that you're going to want to look at your solicitation and point out. And when you're doing this analysis, you don't want to just think of, especially in infrastructure and construction, you don't want to just think of, what clauses do I need when I'm trying to figure out the bid and I'm trying to figure out, getting the job. Look and see if there's stuff missing that's going to make it hard for you when you get to the performance stage. If the changes clause is missing, if the differing site condition clause is missing, bring it up now. It might not actually matter to you, the changes clause not being there might not result in a change in the winner, but it's going to result in a problem down the line when you need to go for an REA, once you get the contract. So, do this as part of your evaluation of, what's good with the solicitation. Now, obviously, you should also be availing yourself of any Q&A opportunities you have with the government. But as we all know, you sometimes get, bid it as you see it. Look at the contract, look at the solicitation rather. Sometimes you don't get helpful answers. Or sometimes there isn't really a good answer because they'd have to redo the solicitation. So you want to make sure that you're availing yourself of the Q&A, but you're keeping an eye on the clock in terms of your deadline. Again, the deadline is you've got to file before the deadline to submit your proposal or bid or quote, as the case may be. Don't do what a lot of contractors do, which is, well, let's see if it works out in our favor. And if it does, no harm, no foul. And if it doesn't, if we don't get the award, then we'll go back and say, well, there was something wrong with the solicitation in the first place. You will be too late. And this is true at the GAO and the Court of Federal Claims and the agency. You will have waived your right to protest if you do that. And also keep in mind that this might mean that your BD team and your legal team are proceeding on parallel tracks. You might get a protest in and also put your proposal in case the protest loses, you want your foot in the door. So kind of be aware of that. The other time that you need to be aware that, the onus falls on you, you need to act earlier than, all the way at the end of the road at the award stage, is in competitive range situations. So remember I mentioned when we were talking about that timeline, competitive range is something that comes up in some FAR Part 15 procurements. FAR Part 15 procurements, going back to that, what type of procurement or what method of procurement is being used, is contracting by negotiation. It's competitive procurement. It's when the government says price is a factor, but we've got all these other non-price factors, and we're going to do a comparison. And what the government often does, you'll see in those solicitations, is say we intend to make an award based on original proposals, but we reserve the right to open discussions with a competitive range and allow revisions to proposals. So the idea is they might just say, yeah, we'll look at these proposals and we'll choose a winner. Or they might go, yeah, we kind of need to bring these up to snuff. They're not quite what we're looking for. Out of the 15 or the 20 or the 25 we got, we're going to pick 10 or 12 or, whatever. They're going to select a competitive range, kind of the best of what they've gotten. They're going to tell everyone else, thanks for playing. You're not in the running anymore. You're not being invited to discussions. You're not being invited to submit a revised proposal. Please do not pass go. Do not collect $200. Everyone in the competitive range, the government's going to have what are called discussions with them. They're going to tell them, what areas they could improve in, what deficiencies were in their proposal. They're going to be allowed to revise their proposals, and then they're going to submit them. The government's going to make a decision on the revised proposal. If you get excluded from the competitive range, don't, put it in your file, calendar it to check and see who gets the award at the end of the process. You need to act now. And what you need to do, we'll talk about in just a little bit. But again, recognize the jumping off point, recognize the trigger, recognize the catalyst, whatever you want to call it. Recognize that your call to action is when you get that exclusion from the competitive range notice. So remember, 2 times at least that you got to act way prior to award. Now, let's move into the more familiar area of post-award protest. This is the action that happens after award. This is still an area of common mistake because, again, a lot of you answered 10 days, which I said is right. But 10 days from what? There is an exception and there is a rule. And the rule and the exception, and whether you fall under the rule or under the exception, is a question of whether you are a member of the required debriefing club. So what I mean by that is the rule is that, again, we're talking GAO, the rule, if you're outside of that pre-award something wrong with the solicitation context that we just talked about, is you got to file within 10 days of the day you know or should have known the basis of your protest. The agency is always going to argue, and the GAO is usually going to find that that's the day you got notice of the award. And for those of you who do business with agencies where stuff is posted, even if they don't send out letters, it's whenever it goes public. It's whenever it becomes public knowledge. The exception to that rule, which a lot of contractors think is the rule, is 10 days from the debriefing. You only fall into that exception of 10 days from the debriefing if you are in a required debrief situation. And what that means is if you ask for it, the government's got to give it to you. And then, even then, it's only if you asked for it in the appropriate amount of time. So, in other words, you only fall into the exception of 10 days from the debriefing if it's a required debriefing and you timely requested the debriefing. So, what do each of those things mean? When is a debriefing required? Far less often than you think. It is required for all FAR Part 15 procurements. It is required for certain FAR Part 16 multiple award, order, like task order type procurements. It is, and this gets a little bit trickier, required for certain FAR Part 15 commercial items contracts if they incorporate FAR Part 15 procedures, but it is not required for FAR Part 8, FAR Part 12, FAR Part 13. If you're doing GSA schedules or FSS schedules, or you're doing simplified acquisition, or you're doing sealed bidding, you do not get a debrief. You might, in certain simplified acquisition and FAR Part 8 and 13 procurements, get a brief explanation. You do not get as much information in those as you do in debrief, and we'll talk about debriefs in a little bit more detail a little bit later on. The government might call it a debrief. You might ask the contracting officer for a debrief, and they might say, here it is. What you're getting is not necessarily always a debrief, even though they say that. And even if you do get a debrief, that doesn't mean it was required. So it's very, very important for you to understand, am I in a required debriefing situation or not? And then the second piece is, did I timely request it? What does that mean? What does timely request mean? Well, you got a notice of unsuccessful offer. You didn't get the award. 3 days in writing, request for debrief. The other situation, competitive range. Remember, I said I would tell you, what you had to do, recognize that your jumping off point is that notice from exclusion of the competitive range. Well, here's where I circle back to that. 3 days from that notice of exclusion from the competitive range, in writing, you request your debrief. If it's a required situation and you timely request it, congrats, you're in the special club that's subject to this exception of 10 days from the date of the debrief. Otherwise, you are 10 days from the date you know or should have known, which again is often going to be the notice that you figured out you didn't get the award. So another wrinkle on this, and this is one of the areas that's the most complicated in a complicated area of law, is enhanced debriefing. So if you are dealing with a defense agency, any of the agencies under the DoD umbrella, when you have a required debriefing and you get it, and you're talking about the debriefing being 10 days, the deadline being 10 days from the debriefing, you actually get an additional amount of time if you ask additional questions. And that is because there is this enhanced debriefing under the DFARS, where after you get your debrief, you have 2 business days to ask questions. The government then gets to answer those questions. And it's at the conclusion of that you then start counting your 10 days. So you can see how the deadlines can be really different. Let's say you get a notice of award on a Monday. It's a not required debriefing situation. Your 10 days starts ticking on that Monday. Compare that to, you get an award notice on a Monday. It is a required debriefing situation. So you ask on Tuesday for your debrief. You get your debrief Friday. It's not a DoD procurement though. So your 10 days starts ticking Friday. Now let's compare that to DoD. Get the award notice, or the unsuccessful offer notice that the award went to someone else on Monday. Ask for your debrief on Tuesday. Get your debrief Friday. Ask questions on Monday. The government gets back to you the following Friday. Now you've got 2 additional weeks, as opposed to the person whose deadline started ticking on the first day. Yours didn't start ticking until the second Friday. So you can see how if you right off the bat, that first day, think, oh, well, I can wait until after the debrief, you lose a ton of time. So it's really important to figure out, where you fall on this thing. And the biggest question is going to be the required debriefing situation. So the biggest mistake is that contractors tend to always think that they're entitled to a debriefing and tend to assume that they don't have to worry about the deadline starting until they get a debriefing. And unfortunately, a lot of times they find that out too late. One more wrinkle on this. Let's recap what we know so far. You guys all know pre-award protests based on solicitation errors before the response date. Everything else, 10 days from what? If it's a required timely debriefing situation, 10 days from the debriefing, but even that can be the debriefing or the, answers to questions after the debriefing. Otherwise, 10 days from the day you know or should have known the basis of your protest. That's often the date of notice. You can sometimes argue that you didn't know anything and, you try, but it can, belts and suspenders, abundance of caution. You never want to have to try to rely on that argument. Now, because this isn't complicated enough and I haven't blown your minds enough, a new wrinkle, the automatic stay. If you are protesting a procurement, you're arguing about, they got the award, but I should have gotten the award. You don't want them to start doing the work while you're arguing about who should be doing the work. It'd be great to call TV timeout, right? Big old red pause button. That's the automatic stay. You can, if you file even quicker at the GAO, get an automatic stay, which unless the government petitions because it's in a matter of national security or some sort of government emergency, basically pauses everything while bid protest litigation continues. Nobody can start work. The contract is stayed. Everything is on pause. This is the reason that most people like to go to GAO. You can get a stay or, it's injunctive relief. It's a particular kind of injunctive relief at the Court of Federal Claims, but it's not automatic. You have to petition for it. There's a lot more paperwork. Your lawyer has to go to DC and sit in a hearing. It's a lot more expensive, therefore, and it's not automatic. And it's not even automatic if you jump through those hoops. You have to meet a very high standard of showing irreparable harm, et cetera, et cetera, et cetera. So if it's important to you to get the program on pause while you argue about it, you're going to want to go in even quicker to the GAO. So we've been talking about 10 days. The deadline for the automatic stay, if you're talking about a debriefing situation, slash all those 10s to 5s. It's 5 days from your debrief. If you're talking about a non-required debrief, it's 10 days from the date of the notice. Or 10 days from the date of the award, rather. So again, it's very quick deadlines. So that concludes the middle portion of today's programming about the myriad of issues arising from the very complicated, very choose your own adventure complicated flowchart that is calculating your protest deadlines. I'm going to move on now, talk a little bit about debriefing, and then we're going to wrap up with, how to spot a winner and a loser and, what to do if you're on the other side. And then we'll leave, about 10 minutes for questions. I did see one question come in. We will get to that in the question section. So debriefings are kind of your big tool, assuming you're entitled to one or assuming that you can get one, even if you're not entitled. Just in that case, remember, it's not doing anything with your deadlines. They're your big tool to gather information, the information that's going to go into your protest. All of the issues that you can try to put together to say, hey, this is what the government did incorrectly. This is what the law said. This is what the solicitation said. This is what actually happened. They're not compatible. That's a problem. There are two different kinds of debriefings. There's pre-award debriefings that usually happen in that competitive range, issue, because obviously, again, you were excluded. You asked for a debrief, remember, because you had to do that within 3 days of that notice from exclusion of competitive range. Meanwhile, the government's in the process of doing those discussions and getting revised proposals, and they're going forward. But, there hasn't been an award yet, but you're getting your debrief. You get a very minimal amount of information if you get a pre-award debrief. You're going to get, whether or not you had any significant issues, the agency's evaluation of the significant elements of your proposal, rationale for why you were eliminated, and reasonable responses to relevant questions that you have to be prepared to pose about whether source selection procedures were followed, applicable regs were followed, et cetera, et cetera. They're not going to disclose number of offers, who they are, what was in their proposals, if there was any ranking, anything about the other offers, and you're not obviously going to get trade secrets, proprietary information, confidential, manufacturing, financial information, anything like that. In a post-award debriefing, you get a lot more. You get the government's evaluations of the significant weaknesses or deficiencies of your proposal. You get the overall evaluated cost or price, including unit prices, and overall technical rating of not only your, but the awardee or awardees offer. And you're also going to get information about how your past performance, but not necessarily the awardees, was reviewed. If a ranking was prepared, which less and less often it is, you're going to get a copy of the ranking. You're going to get a summary of the rationale for award, which I've seen be, a very long, detailed paragraph about how they conducted the best value analysis. I've also seen it be like, because they and not you were the best value to the government. Really depends on how busy the agency is, what agency you're dealing with, how big the procurement is, etc. If it's a commercial items contract, you're going to get the make and model. And again, we see that language about reasonable responses to relevant questions, because that is the most important part of debriefing. What you're not going to get, again, in post-award is you're not going to get a point-by-point comparison. And you're not going to have, basically anything that's proprietary, confidential, protected by Freedom of Information Act exceptions, trade secrets, et cetera, et cetera. So you can't use this as a fishing expedition to get a lot of secret classified information in case that was your plan. In terms of what you were looking for, again, it's going to be, what did the government do incorrectly? Was there an issue with how they applied the evaluation factors? Was there, an issue with disparate treatment? Did they use an unstated evaluation criteria? Did they not appropriately apply the ratings definitions? Did they mix up two contractors? Did they give too much credit to someone who was relying too much on their joint venture partner or their teaming partner? It's really going to depend on what your particular procurement was supposed to be evaluated on and what you think must have gone wrong for you not to get the contract. For example, past performance is the most important project or most important factor. I've been in business 30 years and I've never gotten a CPARS that was anything at less than exemplary. This award went to someone who I just looked up. They've been in business 3 months and I also see them on the exclusions list. I mean, that's obviously a very extreme example, but things like that. Preparation is really key. You're going to want to work with your internal team and your lawyer to the extent necessary to come up with those reasonable questions or relevant questions. You're gonna, to the extent that you are given an option, which you aren't always, you want a telephonic or Zoom debrief. The reason being, you're gonna get a lot more information if you can have a back and forth dialogue with those questions that you have a right to ask. You get that a lot less of that with the written debrief. And as particular, yes, if you've got the enhanced debriefing that we talked about, you're going to have that, back and forth where you get the additional questions you can ask, but you're not going to get that if it's a non-DoD, non-enhanced debriefing situation, which means it's even more important to, especially if you're getting a written debrief, ask questions in advance. So you always want to make sure you are availing yourself of every opportunity to ask questions, gather information, etc. Clients often ask me who should attend, if I should attend. I generally don't think your lawyer should attend. You tend to get less information. If you're dealing with particularly difficult people on the other side, I'm happy to be there. I've been in plenty of debriefs. But I think generally, if you can handle it yourself with good notes and good preparation and then good follow-up with your attorney, not everyone loves us. I know that's a shocker, but you have us at the meeting, you're going to get less information. Obviously, you always want to comport yourself with professionalism. You don't want to be kind of acting in the debrief like this is a confrontation. You want to make sure that it's an information gathering tool. And it's not a bad idea to get a debrief even if you win. You'll learn something. Like I said before, you might not get a debrief. You might only be entitled to a brief explanation. It's harder to gather information that way. It's kind of the point. It's kind of why it's set up that way, or at least that's my impression. But you also might be able to find some information online. Like I said, if you can look up something on, the Federal Procurement Database and figure out their history, or if there's stuff on their website that makes it seem like they don't actually do this type of work, or, there are news stories about them being terminated for default. There are things you can find that are publicly available, to be clear, no sifting through stuff you're not supposed to be in, but publicly available information can be helpful as well sometimes. One of the most important things to do is to talk with your lawyer up front about, how likely am I to win this protest? Protests can be difficult to win. It is not worth it to you to sink a lot of money into paying someone like me if it's not going to result in revenue stream and an ultimate award to you. So you want to make sure you avoid the dead losers. There are jurisdictional issues. For example, if you have a task order, you can only protest a task order sometimes. and you can only protest them if they're over a certain dollar amount. That dollar amount is different if you're dealing with a civilian agency versus a defense agency. It's 10 million civilian, 25 defense. You also have to be able to show standing, that you are an interested party, that you had a good chance of getting the award. If this error that you're saying happened actually happened, if they corrected it, would it make a difference? Great, the agency messed up evaluating prices, but you still were considered unsatisfactory on the first, most important three factors. So, okay, let's fix the pricing. Oh, that's right. Your competitor still gets the award because you were unsat on three of the important factors. So you've got to have to be able to prove that, this was wrong. And if you fix it, the result is different. And overall, just not all protests are created equal. Objective arguments where you can show that something is apples to apples, numbers, objectively incorrect, are going to be successful far more often than I should have been rated higher because I think I'm better than you thought I was. My mommy thinks I'm very special and therefore I'm definitely better than average, or I'm definitely better than acceptable, and I should have been exceptional, or I should have been outstanding, or whatever the ratings are, isn't going to get you far. For those of you who are football fans, it's kind of like overturning the ruling on the field. You got to prove that it was, the original call was unreasonable, arbitrary, capricious, wrong. If reasonable minds could differ, or if it's kind of like, I don't know, we can't really tell, it could go either way, the GAO, the Court of Federal Claims, are going to defer to the agency's judgment. So that's all there is to it. And you also want to talk about, what a win looks like. Even if you can win the protest, do you actually have a good shot of getting the award, or is it just going to be a protest that then takes it from one of your competitors and gives it to another competitor? If you don't end up with the revenue stream at the end, why are you bothering? So have these honest conversations with your lawyer. They can be painful, but it's better to make a decision now rather than go for 3 months and spend a lot of money on someone like me and you really don't get anything out of it. Finally, before we take questions, I want to talk about the flip side. If you are protested, remember, when you're talking about bid protests, you're alleging that the agency did something incorrect, that they did something wrong in the source selection process. They will step in to defend the award decision. So you've got the award. You theoretically could just sit back and let the agency defend the award. You don't want to do that, though. You want to get involved. You need to protect your rights. 2 reasons. When the protest first starts, you and the agency are on the same page. The agency might eventually become convinced that the protester has a point. You might not. You don't want the agency to go, oh, well, we're going to take corrective action. Sorry, you're out of an award. If you can continue to defend your award, you want to do that. And also, government counsel might need assistance. They might be new, they might be overburdened, they might be inexperienced, they might be less familiar with certain arguments just because they've done this less, or just because it's never come up in a protest that they've dealt with. Or it might be that you're better factually situated to make a certain argument. It's very easy to intervene, and then you can kind of monitor your efforts and your legal costs from there. So always, always, always intervene. Don't just count on the government to step in and do everything for you. And on the size and status protest, again, not our focus today, but the government does not step in. It is entirely on you. Don't make the mistake that you think the government's coming to save you on a size or status protest. It's up to you and only you to prove your eligibility. The bonus tip, this is a lot of information. It's a lot to cover. It's confusing. Like I said, the goal is you should know when to pick up the phone and ask a question. So don't be afraid. Now, put them in the chat box. Reach out to me individually afterwards. Whatever you like. Reach out to another attorney if you have another one engaged. Don't be afraid to ask questions or seek guidance on this stuff. It's complicated stuff. So with that, I will open it up to questions. I'll put my info up on the screen as well. All right.
All right. Well, great. Well, Maria, I definitely appreciate that. That was as you mentioned, there was a lot that was in there. But don't everyone, the slides will be sent out afterwards, so you can definitely we can you can look at it again. But we do have a couple of questions in the chat. And I think the first one we'll go to was from Caroline Wang. If the agency filed notice to corrective order to move the solicitation for a rebid from LTPA to the best value trade-off method, I think it's a 2-part question. What do I do to win through the protests versus a recompete? And the second part is, does the protester get a refund for the protest filing fee?
So I think I'm trying to read in a little bit there in terms of the exact fact, but Generally speaking, when you win a protest, you don't get the award. So even if you go all the way through the process and the GAO says, you are right, protester, the government messed this up, what happens is the government goes back and reevaluates. And, what scope of reevaluation it is and how far they go back are going to depend on what you were saying went wrong. So your win is that it goes back to the drawing board and the agency makes a new source selection decision. So you don't walk away from a protest with the win, with the award, I should say. You're not going to get refunded the protest filing fee. Those are kind of considered administrative costs. You can, in some circumstances, get part of your attorney's fees back, depending on certain things, a good portion, if the arguments that the government was making are inaccurate. But usually, if they take or I'm sorry, unsubstantiated. But if they take corrective action early in the process, that's usually considered, they did what they were supposed to do once they saw a valid argument. So you're not usually going to get your attorney's fees back in that situation.
So we have one from Bradley. Is what is the burden of proof required for a bid or award protest? And is there a penalty for protests found to be without merit or substantially capricious in nature? So yeah,
So
I'm trying to make sure I understand the question. Yeah, but so what's the burden of proof required for a bid or award protest?
So there's not like a burden of proof in the same way that like it's kind of encapsulated in other types of litigation. So like you don't have preponderance of the evidence or like guilty beyond a reasonable doubt or anything like that. You basically have to show, like I was saying at the end, that the agency made a mistake. Not just that reasonable minds can differ. Not some people prefer blue to green, but the agency preferred green to blue. But that like no, the agency absolutely made an objective, unassailable error here. And it's on you as the protester to prove that. And yeah, there are sometimes where your judgment's going to be off. And I think there's, a line where you've got a winner, there's a line where you're like, it's worth a shot. And then there's a line where it's like you're dead in the water and you shouldn't even try. There isn't necessarily a penalty, like you're not going to get, I mean, lawyers aren't supposed to file frivolous things, but you're not going to get like a penalty or be blacklisted for filing a losing protest. It's probably not wise to file one that's just throwing stuff at the wall. But there's not like a penalty, like you're not going to have like a $600 fine or something like that. But if you do it enough, you can be barred from certain things. There was a protester, I don't know, probably 5 years ago, who I think had filed like 53, like it's a number like that that's sticking in my head. And they actually basically were prohibited from ever filing a protest again. But obviously a very extreme case. I think that the key takeaway is just have an honest conversation with your lawyer about your likelihood to succeed and whether it's worth it to you to give it a shot, or whether this is one that unfortunately you've got to pick your battles, and this isn't one of them. No, I usually say know when to fold them.
Got it. Okay, great. And Maria is happy to stay on for a couple of minutes afterwards if anybody else has any more pinpointed questions on that. But we do want to wrap up the program. We're getting close to 1 o'clock here. So but Maria, thank you for this. It was a great presentation, and thank you all for participating in today's session. So we definitely appreciated your time here today. We had a lot of interest for it. But before we wrap up our program here today, I'd like to share with you some of our upcoming events that we do have planned. So please mark your calendar for some of our upcoming local post events, as well as some of our upcoming national events. So we are committed to bringing you more content and fun events for the rest of the year. Because of the upcoming National Small Business Conference, the first week of November, our next First Friday will be on Friday, December 3rd, and all registered participants will earn one PDH certificate, and it'll be learn how to develop audit-proof rates, costs, and withstanding federal audits. And the presenters will be Doug Hitchman, Tim Gisby, and Dana Malarney from Fox Rothschild. And registration is actually open now. And are you interested in sharing some of your knowledge and educational topics for our first Friday with our members? So we are accepting presentation applications for next year. So visit our website if you'd like to submit a topic today. And our most popular social event of the season is happening next week. And so our new fiscal year social happy hour is going to be at the Capo DC Speakeasy. So join VIP guests from Space Force Command, SAME National, and all of our DC Post sponsors and our board of directors as we gather to connect, communicate, and collaborate and start the new fiscal year. So it's always a great event and prize giveaway. So it's definitely a place you don't want to miss. So on Thursday, October 19th, the DC Post and CMAA National Capital Chapter for the 2023 Fall Joint Conference, featuring national security programs from GSA and FBI. It's a one-day conference. Help you understand the agency goals, trends, opportunities, and strategies for the new fiscal year. We do have some seats left, so please be sure to register as soon as possible before the event sells out. And as we've mentioned, the Small Business Conference is the first week of November. Expo Hall has already sold out with over 500 booths, and we're expecting about 5,000 attendees in San Antonio. The DC Post is attending, so we'd love to see you there. So if you haven't already, please sign up and book your hotel and flights, and we look forward to seeing you there. We also want to let you know some of the upcoming leadership deadlines. The National Leadership Leader Development Program applications are open now, and they are due the first week of December. The program is intended for mid-level career development and is part of the national program, which includes a rigorous program for a year connecting all posts and leaders from around the SME global posts. Our local DC Post and Nova Leadership and Mentoring Program applications open up next week. This is a year-long program for young professionals, SAME members 39 years or younger, and those in any post may join. You must be able to join in a local area for in-person meetings, so please look for an email from the post next week, including an invitation to celebrate our LMP program graduation on Friday, December 9th. And also look out for the DC Post annual awards nomination applications that will be out mid-October, and nominate any high achieving and celebrate their achievements during our annual awards program in January, along with our military service branch awards, as well as our DC Post board installation. So please be sure to visit our website to mark your calendar for all upcoming events and programs, as well as mark your calendar for all national events as well. So again, thank you for coming to our first Friday luncheon session with Maria from McCarter in English, and look for document delivery with an email subject line and your PDH certificate, as well as the opt-in registered participants today. And we'll be posting a recording on the website later this month. So have a great weekend, everyone, and we look forward to seeing you out hopefully on Tuesday. So thanks again.
Thanks, everyone.
So here's a question for you, Maria. So I think Carolina was onto something. So even though you pay the processing fee for the bid, you can't get a refund on it. That's basically like saying you apply to college and you don't get in, you can't get the refund.
Exactly.
There's nothing stopping you from canceling the check.
Usually it's a credit card payment that you do through and it's something that we do when we file. But yeah, those are generally considered administrative costs. And I think it's $350 if I remember correctly at the GAO to file. And that's actually new. Well, I guess post-COVID time is relative, but newer. It's definitely since I've been practicing this type of law. It used to be that there's always a filing fee at the court, like there is in any court. GAO, you used to just email your protest in. It used to literally just be like at protests.gao, or protest.gao.gov or whatever. But now you actually have to go and file on EPDS, and it's I think $350. Maybe it's gone up because of inflation. But yeah, that's not recoverable. But in certain instances, your attorney's fees or a portion of your attorney's fees are recoverable. It really just depends on like kind of how far the government pushed, refusing to back down and how unreasonable it was that they did that. You have to petition for those costs separately, but usually, you can get them if what the government did was egregious, which is why the government is motivated. I mean, the good side is that that's why the government is motivated to voluntarily take corrective action instead of drag out protest litigation. They'd rather, just say, okay, you're right. we'll go fix it, as opposed to be told 3 months down the line to go fix it, and then they might have to pay you.
Yeah. So when you said some of it is recoverable, like, is that obviously that's on a case by case basis, but what can be actually recoverable?
So it's usually broken down by argument,
Mhm.
which is why it's very important, if if you're a lawyer that does this, to make your time entries very specific about, like, drafting section of brief on this argument. Because if it's considered like, you win on 3 out of 4 of your arguments, but the other one, the GAO goes, no, like that's not a winner. Theoretically, you should be only getting your fees back for the arguments that were made. And usually the attorney's fees are capped. Like there's a set level that then is adjusted for inflation every year. So depending on what your attorney rates are, there's going to be a delta between, what you can recover, and what the rates are. And then obviously it's per argument. Um, but you've got to kind of parse it out, and it can get a little bit tedious. I mean, I've been involved in petitions for attorney's fees where we've literally attached our time records with like highlighted time entries for certain individuals and whatnot. Um, but I mean, usually if you've just got a slam dunk protest, it doesn't get that far. The government just takes the corrective action that they need to take. So.
Got it. Okay. And then Sunil, I apologize if I'm saying your name wrong, but they ask, what is the success percentage from past data?
So there are percentages posted, and I apologize, I don't know the number off the top of my head from this latest year. And actually, I don't know if they put
Ballpark it. Yeah.
Yeah. I mean, what they define as success, as in like you win when the GAO tells you, and this is for GAO because it's a statistic that's published by GAO, it's not Court of Federal Claims. I think is like, I don't want to say 40, 45, something like that. But that doesn't count all the times that the government takes it upon themselves to correct it. And also, like, if you look at the flip side, like the losing protests, doesn't count all the times that stuff is dismissed before it gets to the merits. So the stats are a little bit misleading in terms of, it's actually better for a protester if it doesn't get to the point where GAO says, agency, you did something wrong. If the agency just goes, oh, you know what, rather than put you through 3 months of litigation and lawyers' fees, we're just going to fix it now. That's not in that 45%.
Hmm.
So a lot of the stuff that gets thrown out earlier and is dismissed is actually better for you. But that being said, it is a hard standard. I mean, it's not, the majority of them don't win. They're hard to win. I mean, if you sign up for the GAO, like alerts, you'll see every day the decisions that come out, and it's pretty rare that you see the one that says sustained. Most of them are dismissed or denied if they get to, that point. Most of the ones where you really have the agency dead to rights, the agency takes care of it earlier. And that's why it's so important to just have a very in-depth conversation with your attorney to kind of suss out your success rate, or potential success rate, I guess I should say.
Got it. Okay. All right. Well, if anybody else has anything, Maria will send out her contact information if you want to reach her offline. And then, but again, Maria, thank you again for this. Everyone have a great Friday, and we will all see you on Tuesday at Capo.
Thanks, everyone. Bye bye.
Thank you.